SJC-13538, Commonwealth versus Adrian B. Hinds.
Okay, Attorney Fraunhofer, good morning.
Good morning. Shall I begin?
Yes, please.
Good morning, Your Honors. Elaine Fraunhofer for Adrian Hinds. I just want to mention to Your Honors that Mr. Hinds is here with me in the courtroom today with one of his family members. I'm going to begin by discussing point one of my brief, which is about the Facebook post, specifically the testimony that the judge heard prior to reviewing the post and ruling they would be excluded because they were, quote, way more prejudicial than probative. The government presented no evidence that Miranda Arthur Smith was of Asian descent, and she testified that she was the one that Mr. Hinds attacked, that she then yelled to her roommate, and Mr. Cherniak then ran outside with a knife and confronted Hinds. Both Arthur Smith and Cherniak testified that Hinds then told them why he had attacked Arthur Smith.
Can I ask you, was there an issue of, on self-defense, the animus between the two combatants?
There was an issue of self-defense. I didn't hear the last part of your
The
question.
animus between the two people involved in the fight?
There was no issue of whether there was animus because both testified that they had animus. Was that answer your question?
Yeah, it was just because we had reversed as far as the motive goes in Mr. Hinds' favor, correct, before. And I was just wondering if the same concerns about trying to explore, give the jury information about what was really going on between the two combatants is relevant as well.
Right, and I think there was all testimony from both Mr. Hinds and from the complainants, well, from Mr. Cherniak. Arthur Smith doesn't have any, or Hinds don't have any contact, really, as far as we can tell from the record, that there was animus between them before this altercation. But what's significant is that both the complainants testified that, this is according to their story, that Hinds told them why he had attacked Arthur Smith, and it was for, quote, messing with his mother. And even by Cherniak's own account, the only physical altercation he had with Hinds occurred after Cherniak had stood in the way of Mr. Hinds re-exiting his apartment, and he started spraying Mr. Hinds with pepper spray while Mr. Hinds is holding a laptop.
I guess
and clearly
I'm
has his
trying
keys
to
in his
figure
hand.
out why in the first Hinds case, the racial animus of Mr. Cherniak was relevant, so much so that an expert was allowed to testify, but it didn't, any sort of racial animus by the defendant wouldn't also be relevant and admissible.
It's for the reasons of that little description I just gave of the alleged assault. Because it wasn't Mr. Cherniak that Hinds allegedly assaulted. It was Arthur Smith, who there's no...
But whose testimony are you getting that from? Because that's not Mr. Hinds' testimony. I mean, his testimony is he looks out his window and he sees the two of them by his car puncturing his tire, and that he went out to confront Nate. Mm-hmm. So you have his own testimony. You're only focusing on the testimony of the complainants, but your client's own testimony is very different.
Well, it's all self-defense in his telling, but also it's the government's theory of the case. And the government is trying to get the Facebook posts in to say they don't say this, they never actually argue this, but what they could argue today is that, sort of the question Justice Wendland and you're getting to, they could support maybe a theory of racial animus, but their own witnesses' account undermine that theory. So it's just clearly not relevant to their case. Why
isn't it for the jury to sort all of that out?
Well,
because your client says, my tires got punctured. My tires have been punctured before, and they have been taken very seriously by the police. He leaves his shower and goes to confront the two, and he ultimately gets sprayed. There's all types of reasons why. Wouldn't that be relevant to saying that this is really not about punctured tires from the Commonwealth's perspective, and it's about underlying racial animus?
Well, I don't think so, Your Honor, when their own witnesses tell a completely different story. So it actually sort of contradicts their story that it was all about Arthur Smith and all about him, her messing with his mother. And, sorry, I just want to get to the,
sure.
If I'm missing a point here. So yeah, and Mr. Hinds does not allege that he assaulted them. He alleged he was
Is your
assaulted. and he was-
argument that it's not relevant because it runs counter to other Commonwealth evidence?
Yes, that is
How can that be the test of relevance? Isn't that usually the test for, if evidence is conflicting, then just because evidence is conflicting, it doesn't mean that it's irrelevant. It just means that it goes to the weight
Right.
of the evidence that, as the jury may evaluate it.
And can I just add to Justice Wolohojan's point? The specific evidence we're talking about is credibility evidence. And that we know that the trial judge says you can believe anything a witness says, some of what a witness says, or none of what a witness says. This is all witness credibility testimony. So how are we making this relevancy in that context?
Well, let me try to answer both questions. So it's hard to, as the judge said when the prosecutor said at trial, like maybe we could get these Facebook posts in if Mr. Hinds claims he didn't know Mr. Cherniak's ethnicity, and the judge says the ethnicity of Mr. Cherniak really isn't at issue here. So, I think it's if it has any relevance, I don't agree that it does, but if it does, it's pretty small. I'm sorry, I lost my train of thought.
No,
Your
it
question-
seems to me that is the stronger point here. I mean, I don't mean to make your argument for you, but it may indeed have some probative value. It seems to me that the question really becomes, is the probative value to a collateral issue, first, and secondly, is the prejudicial weight of the evidence such that it outweighs whatever probative value there may be on that collateral issue. That seems to me the crux of the issue. So perhaps you could address that a little bit?
Yes, Your Honors. And I think you kind of summed it up pretty accurately there, that any probative value it has is pretty small. Again, these posts, another reason the trial judge said he was going to not admit them right away was because they were so old, they were many months old. Obviously, they're extremely prejudicial. And so when you're talking about something that has fairly low probative value compared to the very, very high prejudicial value, the balance of those two, especially on a collateral issue, is clear. That is.
So, and now can you please tie all that to what I think is perhaps the only live issue at this trial, which was self-defense? I mean, it looks undisputed to me that that your client, there's not really a dispute that your client hit two people with a hammer. So in some sense, the elements of the crimes are not really live issues because they're satisfied by pretty much uncontradicted evidence. We're really in the core of this case is really the self-defense defense.
Right, and that's
So
what.
Can you tie that, though, to the argument about the error in admitting the evidence to its prejudice with respect to that, the sort of limited nature of the question that the jury needed to determine in this case?
I will try. I mean, I think the point that I think we're both on is that there was a reason that Mr. Hinds was permitted to introduce, and getting back to Justice Wendland's question, Mr. Cherniak's 211 tattoo, or if it was a 211, then and the potential indication that suggested he had anti-black animus, and the reason was that it supported, clearly supported the self-defense argument that there was a reason that Mr. Cherniak slashed his tire and then assaulted him, whereas this, of a 5-month-old or whatever it was, Facebook post that shows anti-Asian sentiment was not, well, I'm going to say not relevant at all, or not, as the trial judge said, his ethnicity has no, it's not an issue here. He attacked Arthur Smith, and this is, that's, and his argument is he was acting in self-defense completely, and the complainant's testimony is that he attacked Arthur Smith, and the Cherniak's testimony is the only physical altercation they had was when Cherniak intercepts him as he's leaving his apartment for the second time and spraying with pepper spray. So unlike the tattoo evidence, which actually clearly does support, and kind of fill in a motive for Cherniak's attack on Hinds, the 5-month-old, whatever month old Facebook posts that have this racial slur don't actually support the Commonwealth's theory of the case, and that's why they're different.
Can I ask you a question? Is your argument different with regard to the text?
Somewhat different, and I mean, it was,
Must be, right? Because the texts don't have that racial element. Instead, they say, will die or will kill, suggesting
yeah, it said,
a premeditated.
death to those in 65, Miranda and 8 will work under false names, et cetera. So it is a little different, that the judge,
So what's the argument there that was?
that it was too remote, for one, and it was a 9-month-old text, and that it is, the language of the text itself is a little bit unclear. I mean, it's obviously very prejudicial, and that's why this is a slightly different argument. It is clearly evidence that would sway the jury with propensity. It would be viewed as propensity evidence when there isn't a lot of probative weight to the evidence. I mean, I'm not denying that it has some probative value, but given that it's 9 months old, given how,
When was the breakdown in the relationship between Hinds and Cherniak before the attack?
Cherniak testified it was around September. This text
Relative to that, how much time between that and this?
and the text?
Yes.
The text predates that, what Cherniak says.
By how many months?
By how many months? Probably about 5 months. I'm just guessing now, but.
Okay, well, we could figure that out from the record.
But this is, I want to point out. it's
But we
something-
can figure that out from the record? It's
Yes,
in
I'm
the
sorry, you
record?
can.
Okay,
Yes,
great,
how many
thank you.
months, sorry. I didn't actually realize this until I was writing the reply brief, that the Commonwealth's brief actually cites several cases, and then I realized that the case that the appeals court cites, which is Commonwealth versus Butler, and all 4 of the cases that the Commonwealth rely on to say that this evidence should have come in, this remote in time prior bad act evidence should have come in, are distinguishable from the situation here for 3 pretty significant reasons. First of all, in all 5 of those cases, the victims were either dead or were refusing to cooperate with the prosecution. So more specifically here, the remote in time prior bad act evidence was not as necessary to provide otherwise unavailable evidence about the nature of the defendants and the alleged victims' relationship. Here, we had Arthur Smith testifying. We had, more specifically, Mr. Cherniak testifying.
So the text would have been admissible if Mr. Hinds had actually killed the 2
Right,
victims?
there would be nobody to counter what the nature of the relationship was. That is a big difference between all 5 of the cases that the Commonwealth cites. And sorry.
Sorry, are you then in the territory where what you're saying is the admission of the texts and the Facebook posts was duplicative of other testimony?
Well,
and doesn't that then undercut the sense that there's prejudice that flowed from its admission?
Oh, no, I think that it doesn't, well, I don't think it undercuts it because the text itself is, it says death to those in 65. Again, the alleged victims.
So are you saying it added anything to the evidence, or are you saying that it was cumulative of the Commonwealth's other evidence?
I'm saying that it wasn't, what I'm saying is that in all of the cases the Commonwealth cites and in the appeals court cites, they needed evidence, the government needed evidence to show the nature of the relationship, to show that there was animosity. And here, well, first of all, Hinds acknowledged that there was animosity, and both of the alleged victims did.
Okay, so
no.
I take it you're saying that the texts are cumulative of other properly admitted evidence.
Yes, and much more prejudicial.
Okay.
Yes, and too remote in time. And in all those cases, the judge had repeatedly given the jury a limiting instruction on how this remote in time evidence should be used and what would be improper use. No such instruction was given
Was one
here.
asked for?
No, I do want to say that. I mean, it was heavily objected to. The trial counsel moved for a mistrial based
Sure,
on it, but not.
eliminates,
You're right.
okay.
And the third difference is that here, the particular prior bad act evidence brought in, a suggestion of other crimes. The text starts with death to those in 65. So this is not the apartment that the alleged victims live in. So it's particularly prejudicial.
Doesn't it say their first names?
Yes, it does, but
Okay.
it starts with this other statement. So
Could you briefly talk about prejudice, assuming that there was erroneous admission of the Facebook posts? Could you talk about, please, prejudice in the context of the case as a whole?
Yes. This case came down to a credibility contest. There was pretty strong evidence in support of Mr. Hinds' self-defense argument. It was just not, an overwhelming case on the government's part. I think the government really likes to.
There was very limited use of the evidence in the prosecutor's closing argument. The jury verdict does not seem to indicate that they were swept away by or inflamed, I'm trying to look at the case as a whole.
Yeah, I'm not sure if I agree with that. In their closing, the prosecutor talked about the Facebook post, repeated the racial epithet, repeated it 2 times, said that, you can't believe him, you'd have to be ignoring his Facebook post. Actually, I think there were 3 references to it in their closing. They hammered on it. And I don't know that I agree that the jury's verdict shows that they weren't swayed by it. I don't know how you would know that. And so in this case, which came down to a credibility contest, where the evidence was certainly not overwhelming, in particular, after it comes in and then, surprisingly, it comes in and then counsel is not permitted to call a surrebuttal witness who could testify that he had, in fact, not authored the post, or at least strongly indicated he had not authored the post, or at least put that question in the jury's mind. The combination of those 2 errors was particularly harmful in this case. I just want to, say the appeals court wrote, here, the risk of prejudice by these errors was high, where the errors all concern evidence implicating credibility in a trial in which credibility was the only real issue.
Chief, would you mind if I ask a follow-up question on that last point? Counsel, I'm interested in the issue about the witness on the surrebuttal. What is it? So part of I understand that you allege that the judge didn't go through all the different facets, but there is the issue of what this witness was going to be called for was about the email address.
It was not just the email address.
Well, what's in the record, in what the defense counsel was talking about, was that there was this email address that was allegedly associated with the Facebook account on the phone, and that somehow she had clicked on a link and it was registered back to some other third person. But again, going back into a more holistic view of this, when the detective testified on cross-examination, he was vigorously cross-examined on, it doesn't mean anything that you could create this or access it remotely and it would appear that somebody on the phone did, and you can't tell us whether or not Mr. Hinds created this or accessed this. That was really covered on cross. But on this issue, though, doesn't this issue get brought up by defense counsel about the email?
Meaning like in her cross-examination of the detective?
Yes.
Yes.
That she then was ostensibly going to be called for to explain. And I didn't see that really addressed in the briefing. Do we at all consider the fact that this was created by defense counsel, this issue? By inquiring about this email address? And the detective doesn't say that it's conclusive of anything. The detective just says it's associated based on this data pull, and that was after questioning by defense counsel. So does that at all go into the calculus for us here about whether the judge abused his discretion?
I think that the significant thing is that Detective Edwards' testimony and then the admission of the Facebook post and the text messages were the last thing the jury heard. I think it would have been incredibly important to the defense in this credibility, weighing case to have somebody pointing out that there was a couple of reasons why it's not clear that Mr. Hinds had any control of this account. And so just by virtue of having a witness pointing out these discrepancies, and it wasn't just the email, what at least defense counsel said was that the expert would testify to was that the review of all of the events in the extraction report created from Hinds' cell phone did not show any evidence that the user of Hinds' phone had ever accessed that Facebook account. Then there's the email, and that the owner of the Facebook account where the posts were made was not Mr. Hinds. I don't think I'm answering your question. I'm sorry.
No, that's all right. I thank you for the attempt. Thank you.
Okay, thank you.
Thank you very much, Your Honor.
Okay, Attorney Calaflores.
Morning, and may it please the court, Joseph Calaflores for the Commonwealth. In 2021, this court reversed the first trial verdict and sent it back for retrial with the aided benefit of the testimony of Sophie Bjork-James. In light of that ruling, trial counsel for the defendant opened by stating that Westfield was a racist town, and in use of that testimony of Dr. Bjork-James, laid racism squarely at the feet of Nathaniel Cherniak. It is in this context that we must analyze the admission of the textbook, the Facebook, and the exclusion of the surrebuttal witness, Lindsay Hawk. Turning to the Facebook messages, or posts, I apologize. The defendant said that the N-word had been screamed at him in the city of Westfield, and that he had been in a relationship with Nathaniel Cherniak, and that relationship had deteriorated over a number of years. Both the Facebook posts and the text messages show that deterioration of that relationship from the genesis of them working out in the gym together through the ultimate act of attacking Miranda Arthur Smith.
So isn't it a collateral issue that, 5 months before the altercation, there was a breakdown in the workout schedules of the victim and the defendant?
Well,
And what the cause of that was?
I guess I'm getting into the heart of whether or not, of what is actually collateral. We have defense counsel opening with this idea of racism in the town.
Well,
And
because
when-
that was central to the self-defense claim, that in fact, I'm sorry about my voice, that the victim, the second victim, had a motive to attack the defendant, and the defendant was responding in kind in light of that racial animus. I don't understand exactly how the breakdown in the relationship a few months ago because of the defendant's racial animus to the victim is central to the Commonwealth's case.
So the breakdown is essential to the Commonwealth's case in light of the opening, where we have a relationship that was friendly. And then there's accusations both ways of certain statements being made about drug dealing and connections to New York City, and accusations.
Commonwealth's theory wasn't that the defendant attacked the victim, the second victim, because of his Asian descent, was it?
It was not.
Okay.
It was not. The Commonwealth, from the opening to the closing, it was that this was an unprovoked hammer attack. The evidence is clear, at least from the Commonwealth's point of view, that Miranda Arthur Smith was attacked outside. We have percipient witnesses that observed the altercation outside. We have Detective Satsos testifying that the use of pepper spray was not indicated within that stairwell or vestibule of the apartment complex. That fact, which is essential to the defendant's version, where he was in the stairwell when he was initially attacked with a pepper spray, and then raised the hammer and went back in the back and forth motion in self-defense. None of the physical evidence supports the attack happening in the stairwell.
Would the Commonwealth's, would your position be the same with respect to the text message and the two Facebook posts if those messages and posts did not actually contain a racial element per se, but just were kind of similar messages minus the racial element, but just indicating animus?
Would the argument for admissibility be the same? I believe so. And when we're looking at it, we also have to take in consideration of the timing of it. And I'm not sure if I've gotten into this, but the breakdown happens early on, and then the attack happens later. But in the meantime, Nathaniel Cherniak did observe the defendant in the hallway, appeared to be waiting with the hammer in an attack kind of mentality. However, nothing happens at that point. Combined with the defendant's statements to his mother, that they overheard, that maybe it was them that they did it, with the inference being either the flat tires or other racial insults being hurled at them within the complex or in the greater town. You can't ignore the greater context of their relationship, not only as neighbors, but their relationship within that town itself. The Commonwealth could not combat the admission of Dr. Bjork James's testimony that 211 on the tattoo allegedly is associated with the 211 Boot Boys, who are allegedly a fan club of the 211 crew, who either are or affiliate with white supremacy or with white nationalism, depending on which 211 group you're talking about. Laying that testimony squarely at the feet of Nathaniel Cherniak in the context of a racial town requires the full understanding of how they became friends, how that deteriorated, and how it ultimately ended up with a hammer attack outside the apartment at 10 a.m.
Can you explain why the judge's failure to allow the rebuttal evidence was not error?
Certainly. The judge was in the best position to judge the credibility of all of the testimony and all the witnesses, and that includes the defendant's own testimony about the Facebook posts, Detective Edwards' testimony about the extraction itself. And so when we're looking at those Durning factors, and we must not only look at the Durning factors, but this court's decision in 2021 in what I believe is footnote 29, saying this court does not anticipate the lack of notice to be reoccurring for any expert witnesses going forward. We unfortunately were in that same position where there was an expert that was not noticed, either in identity, basis of testimony, or expected testimony outside of the expertise.
But
So
the defense wouldn't have called the expert, except that the Facebook posts were let in sort of at the last minute.
Certainly. And so that's when we're looking at the Durning factors and the standard of review, that it's an abuse of discretion for both the Durning as well as rebuttal and surrebuttal. There's layers of abuse of discretion here that we must take into context. When Judge Ferrara was looking into the whole expert testimony issue, he expertly asked, was this person known or testified? And yes, the expert was known. However, the expert had testified or had written a report about something unrelated to cell phone extractions. She had been brought up in the context of a cellular telephone ping, which was the subject of a motion to suppress, which was denied prior to the first trial. So yes, the Commonwealth, and as a practitioner in Hampden County, is well aware of who Lindsay Hawk is. However, her testimony as to Facebook extractions from cellular devices, as well as her discovery of a witness named Luna, left the Commonwealth completely surprised as to the Durning factor.
Well, counsel, this is the point I was getting at with your opposing counsel. So this really happens over 2 days. So there's the end of that first day, right, when this issue comes up, and then the proffer the next day. What I'm still confused about was that it seemed that Hawk's testimony was going to directly put in context the email address that was associated with that Facebook account. And that was elicited by defense counsel that created that. And so I'm still wondering, does that at all factor into the factors here? Because the trial judge, even though he may not have said explicitly going through these factors, he talked about the extraction. He talked about that you had the extraction ahead of time, including the email that was ostensibly associated with it. So how does that factor in?
I think looking here, yes, the judge did not explicitly consider the defense counsel's opening of the issue. However, on review, I do agree, as I think about it for the first time standing here, that defense counsel did seize upon the moment to ask about this email, which was associated with a website URL, facebook.com, not through an application, but through a browser on the phone. So the argument would be that this person used the phone in a browser to access Facebook. And so I would generally say that that's an issue of credibility as to whether or not we attribute that email boy toy with the defendant or accept the alternative argument that it's someone else that used that phone to create the Adrian Anomaly Hinds Facebook account and then create those Facebook posts. A little bit of inference upon inference based upon the record.
Let's assume that can you explain how the defendant's racial animus or racial prejudices, let's say, are relevant to the live issue of self-defense, the real core issue of self-defense in this case?
When we're looking at the self-defense instruction, it's a reasonable belief of attack. And when we look at the defendant's own version of how the attack happened, and even when we look at the version that the Commonwealth proffers, the defendant was in his apartment. He then sees a 12 to 16-inch blade withdrawn from the pants, slashing or stabbing the tire. He then leaves the safety confines of his apartment to confront the two victims. When we're looking at it, it's not a reasonable belief of attack there. When we're considering the self-defense theory,
But if I could just stop you for a second to focus more narrowly on the question that Justice Wolahojan asked you, how does the defendant's racial animus against the victim, X months old, or even currently existing, help the Commonwealth defray the self-defense argument, which was the only thing that was at issue?
And I think it's right there at that moment. That decision to leave the apartment shows that it was not a self-defense. So we're looking at the credibility.
But how does that affect, how does the Facebook posts fit into that story?
It's this idea, and the Commonwealth did not linger upon this at trial. It's the idea that the defendant is so incensed from the racism in town, and then he has a specific racial prejudice against one of these victims, which may be attributable to Miranda Arthur Smith, who lives with Nathaniel Cherniak in the apartment.
I think we have to be a little careful here. What's concerning me is the idea that someone who harbors racial prejudices is not entitled to a self-defense defense. Do you see what I'm saying?
I do see that, yes.
That would concern me.
Yes.
So why are we not in that zone here?
Why are we not in the zone of
That
the defendant not being entitled to it?
problematic conclusion? That a racist cannot be entitled to self-defense.
I think we must look at it in the inverse, who is entitled to a self-defense instruction. It's any reasonable point of view.
Who meets the elements?
Right.
Right.
And if we do look at the defendant's theory of the case, he does at least meet somewhat of this idea of self-defense either of himself in the hallway or self-defense of his vehicle upon seeing it being, the tires being slashed, which he had been suffered to his testimony many times over.
Well, there's also the upstream issue, because the Facebook and the detective's testimony comes after Mr. Hinds' testimony.
That's correct.
And that's where the judge revisits that decision, the evidentiary decision, because there's the testimony that I know that your opposing counsel disagrees, but there's the testimony of never having said anything negative, or I forget the formulation, but there was the affirmative testimony from Mr. Hinds that I didn't have a beef with them, and so I never said anything negative or anything. So the fuller context is also, isn't that going to inform the reasonableness analysis for self-defense?
I believe so, Your Honor. And when we're looking at that specific testimony, there was a lot of discussion about towards versus to, right? The question is, did you ever use a racial epithet towards Mr. Cherniak? I never said anything to him. And I think we must give the trial judge here some credit. He's listening to the testimony. He understands what is going on in this specific line of questioning. And there's a line between not having a good relationship to someone disliking, to someone hating, to having a racial prejudice against something. And I would credit the trial judge's determination at that moment that he didn't believe what the defendant was saying was completely truthful. That defendant there was almost playing with the answers to the questions that the prosecutor was asking. The changing of towards and to, and the retorting, isn't that a negative relationship with them? It's clear that he was being deceitful, and therefore it was proper to inquire further and to admit the Facebook posts. If there are no further questions, the Commonwealth would rest on its brief.